Everybody. Hello, everybody. Welcome to our morning session, which is the art of incremental trust building and dispute resolution. And the two speakers will be Vicky Visca and Professor Michael Saini. I'm going to turn it over to them to present for themselves. I just want to let you know that we're all excited about the knowledge and expertise that you both are going to share with us today. And I'll turn it over to you. Also, all questions will be answered at the end in your chat, or if individual people want to ask questions at the end. So I'll turn it over to you, Vicky and Michael.
Thank you. Michael, did you want to start, or do you want me to start with the introduction?
Sure, you can start.
Okay, great. First of all, I'm very excited to be here, and it looks like we've got about 20 participants. And after we introduce ourselves, I do want to have a little quick go around just to see who's in the audience so that we can even further tailor make this presentation for your needs. So I am Vicky Visca, and I am a child protection mediator and a child protection trainer. I'm recently been appointed as the program manager for the Ontario Association for Family Mediation, which oversees child protection mediation program. I'm a family mediator as well. I've been a family mediator for about 40 years, and I train in family mediation. I do a bunch of other stuff, but that's really the bulk of what I do. I'm the former president of the board of OAFM, and as I said, I'm excited to be here with Michael. Michael?
I'm Mike Saini, and I'm from the Incremental Faculty of Social Work, and I'm also cross-appointed with the Faculty of Law as Associate Professor. I'm the co-director of the combined JD MSW program and the chair in Law and Social Work. What brings me to this topic, first of all, is just to be able to present with Vicky whenever I have the opportunity. I jump on it. I like working with Vicky, and she's a great presenter and a great person, and I just always like opportunities to do these projects with her. So that's first and foremost. Second is that I've been working on trust and respect for the last couple of years as an alternative to focusing on high conflict separation. Specifically with a co-parenting tool that I developed with Marsha Pruitt from Smith College. We found that trust and respect were the two strongest domains of co-parenting. And so rather than, as we have for the last 40, 50, 60 years, banter around what we're going to do with these high conflict situations and put boundaries around them, but that's as far as we've really got with high conflict. Trust is a new, it's been around for a long time, but it's a new way of thinking about the work that we do. And this idea of incremental trust, Vicky and I have put this together. This is something we're going to have to write up. I think it's new. I think it's innovative, and it gives me lots of energy to present for those two reasons, and to be with all of you, of course.
Thank you. Michael always warms my heart with those lovely introductions, and the feeling's mutual. So thank you so much, Michael. I guess I'm just wanting to get a sense of who's in the audience. So maybe, well, you don't have, many of you don't have your screens on, but even thumbs up. Can I get a sense of how many ADR practitioners are in, like direct ADR practitioners are here? So we've got a couple, okay. And I can see we've got a couple of ADR program managers in terms of transfer payment agencies. So we've got a couple child welfare agency representatives. Okay. Who else is maybe by way of introduction, just in terms of what your role is, just so we can maybe tailor make the presentation to meet some of your needs. What are some of the other roles that, yes, Nancy? Oh, we can't hear you, Nancy. No.
No.
Oh, now the magic happened. Yep, go ahead, Nancy.
My apology. I am a family group conferencing coordinator.
Perfect. Okay, so that fits under the ADR. Okay, great. Any other roles that are within the group? Those of you who wish to share.
Hi.
Yeah. Hello.
Hi, I am a Masters of Law student. I'm
Okay.
Jane.
Oh, hi, Jane. Thank you for joining. And B Young, you have your hand up.
Yes, hi, good morning. My name is Brenda. I work
Brenda,
as the Justice Director for Chippewas of the Thames First Nation.
Okay, so we certainly have a mixed group of participants, and so we're looking forward to this. So if I got a couple of things here I need to spotlight. Nope. We were spotlighted before, Michael. Oh, wait, the view maybe. Speaker view. Okay, there we go. All right, so I will bring up the PowerPoint and go from there. Okay, first of all, can everybody see that? Yep, okay, wonderful. Got too many things going on here.
I trust you, Vicky.
Thanks, I'm glad you do. I don't trust myself here, okay. Okay, I've got a few jobs here, so I'm also admitting people at the same time. Alrighty. All right, so I guess one of the things I want to reinforce here is a lot of what we're discussing here today is going to sound like common sense, which is good, right? But what we're going to try to do today is build a framework around the art of incremental trust building. And some of the learning objectives that we want to address today is identifying some strategies that we can use, applying some interdisciplinary insights into the practice, and overcoming some common trust barriers through case analysis. So there will be a case that we will discuss later on in the presentation. So why is it important to consider trust in dispute resolution services? So certainly as mediators, and I'm coming this from the framework as a child protection mediator, but certainly it's applicable to other alternative dispute resolution strategies as well. As mediators, we give a great deal of thought and consideration to planning regarding screening, rapport building, setting the stage to maximize the potential for success in mediation. One of the things I'm not sure we spend a lot of time on, where I think we could perhaps direct some attention to, is trust and how trust is an integral component, not only during the mediation process itself, but beyond mediation for when families need to carry the torch and plan beyond the actual mediation. So building trust ensures that information can flow freely, which can assist in a comprehensive understanding of the issues at hand. So as noted here on the slide, trust is often discussed, but seldom is it operationalized within dispute resolution services. And a lack of trust may result in resistance or reluctance to participate fully in the resolution efforts. If people coming to the table are fearful or are lack of trust in those that are at the table, it can really be a barrier in terms of effective dispute resolution. Trust building is not only about resolving the current dispute at hand, but also about laying the foundation for future relationships. Sorry, I think I need to move some things here so you can see the screen. So the potential benefits of integrating trust and dispute resolution services. So mediators and practitioners are more likely to be effective when trust is established, as I mentioned a moment ago. And participants who are part of the alternative dispute resolution process are likely going to accept resolutions if they believe the process has been fair and unbiased. Trust is conducive to collaboration, allowing for creative problem solving and a more amicable resolution. it really, I mean, overall, it contributes to a sense of satisfaction with the outcome. And it's crucial in addressing emotional aspects of the decision making as well, which we're going to get into a little bit later as we go through some of the scenarios as well as the case examples that we will discuss as we go along. Michael?
So, yeah, so as Vicky mentioned, trust is a word that we know and use a lot. It is in our language. It's the way that we talk about relationships. It's how we talk about our technologies. We want to make sure we trust how we use the technologies and whether they're available for us. So trust is everywhere, but how do we actually define it? It's not a term we've actually spent a lot of time thinking about. In fact, when you look at these definitions, one thing that you notice that these are 1990 references. And so what's happened in the 1980s and 90s, there was a lot of flurry around what this trust concept was in psychology. And then it went quiet. And it wasn't really until technology has taken up this concept of trust, because of course, for people to go into cars, they're going to drive themselves. You really have to figure out how people are going to trust those cars to be able to do that driving on their own, or else no one's going to want to be in those cars. And so the AI and the technology fields, the computer science fields, they've been doing lots of work around these concepts of trust. And so now we're actually borrowing from them to understand trust. But in trust and ADR, it is an important concept. And we need to be thinking about what we mean when we talk about trust. So here, McAllister talked about a person is confident and willing to act on the basis of the action decisions for another. So there is a risk analysis of trusting somebody. Why do we trust this person or not trust this person? And what are the cognitive and affective makeup of that? So we have two parts of the dimensions of trust. One is considered the calculus-based trust, which is here we're talking about the cognitions, the rational calculations of why one would trust the other. I trust A because I believe I have good reason to do so. So it's a calculated decision. So if you're in a relationship and you have a good working relationship with the other person and you understand what is to be expected from that person, then you have no reason not to trust them. But if there's trust violations, if there's transgressions in your relationship, then you're going to be thinking very differently about whether or not it makes sense to trust. And so when people come to mediation, or they come to the services of child welfare, or they come to the services of legal professionals, what happens is that there's often very little in the bank that has been left in there from the relationship. Most of it has been withdrawn because of trust violations and transgressions. And so their calculations of not trusting the other person actually makes sense because there's nothing to build on that trust. And so, that's one thing that we'll talk about is how do we make it so that we can improve the calculus-based trust. The other is the identification-based trust, refers to the close emotional attachments that we have with others. I trust them because I have a strong relationship, and I think they're going to do me no harm. And this gets complicated when your calculus-based trust says, no, actually, they probably will do you harm based on the patterns of previous behaviors. So then I fear that they won't trust me. And there is this competition of calculus-based versus identification-based trust at play. So, Chua reminds us that these are on dimensions of the head and the heart. So our heart says, yes, it'd be great to be able to trust this person. I have a relationship with them. I have attachment with them. I have, a history with them. But my brain says no. My brain says I should not base on previous violations. And so even when we're trying to promote trusting relationships post separation or post involvement of child welfare, we need to be thinking that it may actually be quite adaptive not to trust somebody in the very beginning. Most people come into ADR services won't trust that this is going to be a good process because there's nothing in the bank. And so if we start building up that trust and we can align the trust from the head and the trust from the heart, then we can really start developing patterns of behaviors that can be built off of each other and grow into a more trusting relationship. So another way of looking at trusting the other is through the cognitive base. So that's the rational calculations again, and the affect base. So looking at the emotional, grounded in reciprocal care and concern. And so whenever we're looking at trust development or trust repair, we need to be identifying both cognitive and affect basis of trust so that we can, not just build in a pattern of what we think makes sense that people could buy into, but they also have to feel that this is good for them. I mean, making decisions, they say, sometimes the best way to make a decision is to flip a coin. And then depending on how you feel about whether it's heads or tails, that gives you a sense of whether that's a good decision. That's your affect-based trust versus your cognitive-based trust. And so those need to be working in connection for trust to start being rebuilt once it's been violated. So trust is there's different components. The ability of trust is the domain-specific competency. Does somebody actually have the ability to act in ways that are trustworthy? Do they actually have it in them? So if my ex-partner is involved in substance misuse and they have not been able to get a feeling of mastery over their substance misuse, then there's going to be an ability problem. And so I'm not going to just trust that they're going to be able to do it. I'm going to need to see that there's the stakes in the ground for markers to look at that success. And so in that situation, maybe doing some testing, maybe doing some therapy, some counseling to try and start moving into a demonstration of ability. The other part is, do they want to? Is this something that they're eager to move forward on and are actually passionate about making the change? Because making any change towards being more trustworthy is challenging, and it does take commitment and whether or not they have that that orientation towards that commitment is going to be important. And then just the integrity, adherence to acceptable principles. Can we establish in a relationship what those markers will be? Can we make sure that we are measurable in our approach so that we can actually measure integrity and measure adherence?
And I just want to add maybe one further comment to that. It also relies upon vulnerability and people's vulnerabilities to put themselves out there to trust as well, right?
Mm-hmm. The other piece that's really interesting, because we're talking about ADR professionals and child welfare professionals, it's important to also understand that trust in authorities has been studied, and there's interesting ideas that come out of trust in authorities. And that the relationship model of trust predicts the trustworthiness. In other words, if we can establish a positive working relationship with our clients, and we are consistent, transparent, we follow through, we don't break promises, or we don't make promises we can't keep, then eventually we then create the foundation for trust. But trust itself is not inherent in authorities. In fact, most people will be cautious with authorities until there's suggestion otherwise that they are trustworthy. And so that's really important as professionals, because we think we're good professionals. We think we're good people, and we expect people to trust us, that we'll do the right thing for them. And that's not the way it works. That trust is actually earned. We have to demonstrate to our clients why we are trustworthy. There's different measures of trust. This one here I found from Ashford and Faith, and this is measuring trust in child protection mediation, which I thought was quite interesting. Actually, it's child protection services, but I thought nonetheless it's really interesting because it looks at from a parent's perspective, do they trust their worker? So did the worker take their problems seriously? Did they help them as much as they could? Did they do the right thing for the family? So again, I mean, often, and I worked in child welfare in Nipissing and Parry Sound. And I often felt that I was doing right for families, that I was doing, the best job that I could. But that was never discussed usually with families. I never sat down and said, like, so how do we build trust together? So that if I'm doing what I think is right for you and your family, that you also think that what I'm doing is right for you and your family. And how do we build that trust so that we can have a common focus on your children's best interests? And so instrumental distress scale also gets at areas where trust violations occur. And it's not necessarily the trust violations that are key, but it's how you respond to those violations, whether you can repair the ruptures and identify those ruptures early on before they become a bigger issue than they need to be, and then be able to put a plan in place to start repairing those once those have occurred.
So I think one of the things to reinforce as ADR practitioners is that when clients are referred to us, it's pretty much understood that the majority of the families that we're seeing, and I'll refer to child protection mediation, but really any form of alternative dispute resolution and child protection, there's been some sort of a trust fracture or a destruction of trust. And that can either be with those families that Michael talked about, where there's been intense high conflict that has warranted the involvement of the Children's Aid Society because of the worry of emotional harm that's being caused to the children by being exposed to parental conflict. It can be a fracture of trust with respect to the worker and the family member or the family members. It can be a lack of trust in the system, in terms of whether or not they've had a history themselves as being involved with child welfare in their own upbringing. And so I think it's important for us to recognize that from the beginning stages of any form of alternative dispute resolution, there has been some sort of fracture of trust. And recognizing and understanding the trust dynamics are important, not only in starting our work with families at the stage of intake, which for those of you who are not ADR practitioners, our work always starts with an intake, but it also would move throughout the process to the joint sessions in mediation and well beyond once they've concluded their work in alternative dispute resolution. So one of the biggest challenges that parents and caregivers have is really rebuilding that trust once it's been ruptured. So what are some common or potential trust ruptures in alternative dispute resolution? So there could be a perceived bias or a perception of a lack of neutrality. I know oftentimes, if not all the time, I need to reinforce with families that when folks come to see someone like myself, we are completely separate and independent from the Children's Aid Society. We're independent, and that we're not here to take anybody's sides. We will be as neutral and as unbiased as we can be, taking into account that there are intrinsic biases, but we're talking more theoretically here in terms of we're a neutral party that doesn't represent anybody at the table. And we also need to recognize that if there has been a historical or an ongoing issue with not following an agreed upon process, that can also create a trust rupture. And certainly as mediators, we thoroughly go through what the process will entail in terms of intakes and joint sessions and the confidentiality of the joint sessions and whatnot, and then the preparation of the mediation report that is prepared at the end of the process. However, if we don't follow our own process that we've outlined to folks, then that can create a rupture in trust as well. If we're perceived or if others are perceived as not being transparent, that can create a fracture in trust. If there have been inconsistencies in decision-making, now to be clear, I'm not referring to decision-making as mediators, because as mediators, we don't have decision-making authority. But if there has been inconsistency in decision-making through their involvement with the other parent or with the society or with another party that may not be a parent, but another caregiver, that can create a rupture in trust. If we as mediators ignore the power imbalances during a mediation process, people may not feel safe during the process, and safety is directly connected to trust as well. It's important that as mediators or other alternative dispute resolution practitioners, that we not create unrealistic promises. We're not going to guarantee anyone that we're going to reach full success during this process. What we can reinforce is that we will do our best to help them work out a resolution that meets the best interest of the child, but we can't make promises that we can't keep. If there are conflicts of interest that get brought to our attention, and we fail to address those conflicts of interest, then that can also be problematic in maintaining or keeping trust. And certainly, we all know that during an alternative dispute resolution process, people are at a heightened state of anxiety and emotions can be abundant. And we certainly can't prevent what someone may say, but as mediators, we need to be able to reinforce with folks that we will address things appropriately. There is an expectation of respect that everyone will have of one another during the process. And if we notice that things are veering in a situation where it is becoming disrespectful or insensitive, then we need to address that in an appropriate manner, whether we caucus individually or whatever the case may be. But they need to know that the mediator has control over that process. So when it comes to building trust, there's what gets referred to as the 4 C's. Clarity, which is being open and honest and clear and concise. There's compassion, where there's a genuine sense of empathy that is demonstrated, and empathy and a general understanding of what's being addressed. For trust to occur, compassion must be perceived as genuine and sincere. Then there is character. We're all being assessed, if you want to use that word. You know, are we being seen as a person with integrity? And then there's competency. Being kind and reliable is insufficient to generate trust. You have to show that you can get things done and that you are capable if you want to be trusted. And that's not only specific to the mediator, but to the participants in the process as well.
So, so I think just up to this point, I think it's good just to think about your own clients. Do they trust you? Has there been any trust violations? What could you have done differently to ameliorate that situation? And one of the ways that Vicky and I have been talking about implementing this into ADR is to think about incremental trust building. And that is the systematic but gradual process of putting the proper steps in place to build trust and then to deal with any ruptures that may have come from trust violations or transgressions. And I'm going to take you through this model so that you have a sense of just those steps that we've been thinking about. And these are our model. I mean, this is our model right now. I'm sure it may evolve, and any feedback you have about it would be helpful. And so the key elements of incremental trust, one is that there's an understanding that trust is not necessarily present at the very beginning of ADR, that it does take a purposeful approach to put trust into relationships and make that a priority. And that trust building happens in small, manageable steps that are measurable, and that you then can move from one step to the next as you build the foundation of trust. That open communication is key, and that we need to make sure that we are balancing power imbalances that may offset people's feelings of trust. Again, what we need here is for people to cognitively think through trust building so that it makes sense for them, but also they must feel their way through this process so that the process feels right to them. And that's the ingredients for trust building. So to do this, and we need to be thinking about how we develop trust in relationships and how we actively address concerns as they may arise, so that a transgression doesn't just get left there, that there's an opportunity to evaluate it, to attempt to repair it, and therefore to help to move the relationship back in the positive direction of climbing up those stairs towards a trusting relationship. And so you want to celebrate all victories. People show up, that's exciting, right? Just showing up is an important indication of trust. Like you don't necessarily trust that this is going to be going well for you, yet you're still here with me, meeting with us. Like, for example, I looked at the program, and there are a lot of really good sessions going on at the exact same time. And so I'm really appreciative that you made this choice to be with us this morning. But you have options, and we see the movement of participants fluctuate as people, they look at different programs to see which one they want to get the most out of, and so we want to reinforce how appreciative we are, and that's what you want to do in mediation or ADR work. You don't want to take those small victories for granted, because those are opportunities that may be missed in the trust building process. And so here's the incremental trust, and Vicky will go into this in more detail. So you have the initial intake. What are you doing from the very beginning to build trust? You want to set that stage for the ADR so that trust and trust concepts are embedded in setting the stage. And so, everything from the location, the people involved, transparency, using some of those trauma-informed principles, and then addressing expectations and being able to have clear communication about what is to be expected and not to be expected, and create some markers of success. You then want to demonstrate effective communication skills and be able to, role model good communication that is conducive to trust building, recognizing those small successes. And then, of course, all the way through this, you are establishing, measuring goals, but you're going to go back and revisit those goals. And then you want to make sure you always schedule a review process to see, to do those check-ins. How are we doing towards building that trust?
So for those of you who are ADR practitioners, this may be common knowledge. However, I'm just going to go through it briefly to review the actual process that Michael just went through in terms of the different steps. So, and I'm going to do this through the lens of being a mediator, because that's where my area of expertise is. So mediators always conduct separate intakes with each participant. They don't necessarily have to be a party, but with each participant. So if someone is going to be attending the joint session, as a mediator, we need to meet with them. We need to understand what their role is. We need to help them understand the role of mediation, the confidentiality process, and what happens at the end of the process as well. During that intake, we are screening for family violence and power imbalances. And I want to just reinforce here that in child protection mediation, it's more common than not that there would be some issues of violence and some issues of power imbalances. Doesn't mean that you're screening out. So meaning you're not saying this has existed, therefore we can't proceed, but this exists. Are the parties still comfortable proceeding with mediation? And how are we then going to tailor make the process to build in some safety, to build the trust, and also that take into account those issues that you've learned about during the individual intake. The other thing that we're trying to canvas is communication patterns. We're getting to know them, and more importantly, they're getting to know us, because they're going to see us as taking the lead in this process, and whether or not they're going to trust in the process to be able to address the issues that are going to get identified. We are wanting to talk about whether there are mental health issues that could impact their ability to effectively participate in the mediation process, whether or not there are substance misuse or abuse issues, and just a general overall sense of some of the background information particular to the participants. I think it's important that during this initial intake, we're really setting the stage, we're setting the foundation for the rest of the process. And this is an opportunity for each of them to tell their story from their own lens. And I think that's important, that people feel that their view, their lens is important for us to hear, and that we're genuinely interested in hearing their story. And that ultimately can help build in trust to the process as well. During the initial intake, we're talking about the process of mediation. We review the confidentiality in mediation, child protection mediation. It's always closed mediation. So the old saying, whatever happens in Vegas stays in Vegas, very true for closed mediation. And we're setting that stage. We review the agreement to mediate with them. And we're just very clear in terms of the confidentiality, that everything that gets discussed in mediation remains confidential. If they're able to work out an agreement, then certainly if everyone agrees, those agreements can be submitted to the court if there is a court proceeding. Now, the only time confidentiality doesn't pertain is if there are new child protection concerns that get raised, in which case we let folks know that right from the very beginning, so that, again, that's not a trust fracture. Then if we have a duty to report something, we would have reviewed with them in advance that if there are new child protection issues that get raised during the process, we have a duty to report like everyone else does. So during this process, we're trying to understand the key perspectives, what their concerns are, what are their expectations of the process. We're really trying to build rapport during this phase, and again, reinforcing the confidentiality to be able to establish trust. I think it's important to reinforce that many families that are coming to child protection mediation or any form of ADR as it relates to child protection, the antes are fairly great. I mean, we could be talking about the permanent removal of a child from their care. And so people are coming into this process with understandably intense feelings of anxiety and fear. And so it's really important to understand where they're at coming into the process. So part of what we're also doing is we are establishing expectations. I don't have a thou shalt not rule list, because that doesn't feel very adult-like when we're meeting with folks, but we talk about appropriate communication. I use humor a lot, even though people are anxious during the process. I try to use it appropriately. And I'll say, if you're talking over one another, I just honestly can't hear what you're saying, and what you have to say is important for me to hear, right? And so we do talk about the expectations, one person at a time. I know people are anxious being here. However, if we can try to speak with dignity and respect towards one another, that will hopefully also role model for you what you would expect from others as well. And the agreement to mediate is reviewed, because that's a key component of highlighting expectations during the mediation process, but also what happens at the end of the process. And that, again, is a way of setting the foundation and hopefully developing some trust. We talk about what happens in terms of the expectations if there is a partial agreement, if there's a full agreement, if there's no agreement. If there's no agreement, then there's no report. We don't get into a situation where we talk about what one person said, what the other person said. We can't be subpoenaed to court to give evidence. We review all of that at an intake stage, as well as when we bring folks in together, in whatever capacity we bring folks in together, and reinforce that dynamic as well, just so that everybody's clear about the expectations. If there is a partial agreement, then we highlight the points of agreement. If there's a full agreement, then we highlight all of those points of agreement that they worked hard to address.
Just the one thing about that too, Vicky, is that I think we need to be asking folks about what are they concerned about? What are their fears about being part of this process so that we can tap into any obstacles of trust building. It may be feelings of safety, it may be feelings of worry, it may be fear of the unknown, it may be expecting too much from the process. And so being able to help them have a realistic expectation, but also address any concerns is so important at that stage and throughout.
Absolutely. Thank you, Michael. During this process, we're also really trying to role model effective communication skills. We try to demonstrate that we're listening with empathy. We're trying to demonstrate that we're actively listening. We may demonstrate some reframing to really reinforce the theme of what people are trying to get across. And it's sometimes it's a bit of a risk, you know, if we say to the other person, what did you hear them say? It's often interesting to hear what they think they have heard the other person say. But then as a mediator, we can then reinforce maybe what the intent was behind the words, right? And really, we are trying to role model during this process some effective communication skills. It's a real balancing act sometimes as mediators in terms of honoring and valuing each participant's expressions of their personal experience and giving each participant an opportunity to do so. We all know that we have some clients that are much more vocal than others. And so it's intrinsic on the mediator to try to ensure that each person's voice is being heard during the process. And again, that relates to the trust. So Michael has talked about the recognition of small successes. And certainly during the mediation process, by the time we get to the joint session, I, as a mediator, should have a fairly good understanding of where people are at in terms of what their goals and objectives are and what they would like to see as the outcome of mediation. And with that, when we create an agenda, I, as a mediator, use my discretion as a mediator as to what topics to deal with first, because I want to build on the momentum of success. And so we may try to address issues where hopefully we've already determined through our private intakes where there's already some commonality, because each success, small or large, then gives you the courage, the trust, and the momentum to build onto some of the other larger areas that will eventually get addressed as well. You know, the fact that they're there, the fact that, you know, as Michael said, I mean, when you think about where people are at and the fear and the anxiety that they have, and that they were able to come on time or come with support, whatever the case may be, it's important to honor and value those successes. So one of the things that we hear repeatedly from clients is they don't know what's expected of them, particularly from the Child Protection Agency. And certainly the workers will say very clearly, I'm sure we've reviewed this with them at least 10 times. However, it may be necessary to really dial it back and say, okay, let's identify the goal. And then we're going to identify measurable ways to address each one of those goals. And what are some of the indicators that those goals have been met? And I want to give you an example of this particular situation. So I recently did a mediation where the children have been in care far longer than they should be with the statutory limitations. They've all been in care for 4 years. And so there is a trial set for next month. And it's for either the two options are extended society care. The children have to return home. There's no other options. We've hit a place in the legislation where permanency has to be determined for the children. It's actually exceeded the time limit, but those are really the two options that are available to the court. And in this particular situation, the two of the older children who are 11 and 10, the others are under 10, are refusing to see their mother, and their mother only sees the children supervised at the Children's Aid Society office. And so the two oldest children have not seen their mom for several months. And there have been trauma assessments that have been completed of all four children. And there are significant traumas and PTSD that have been diagnosed for all four children. So one of the things that we needed to work on during mediation was, you know, certainly the mother is clearly, and to the gratitude towards her lawyer was really instrumental in letting the mother understand there are two options here. A continuation of what's been happening in terms of let's wait and see is no longer an option. And so we needed to work on a checklist of what the mother could demonstrate in terms of, because she was looking at agreeing to extended society care, but wanted to ensure that her time with the children would eventually be increased if that was at all possible, but there were certain steps that needed to be met. And so we identified, and we actually came up with a checklist. And, you know, was she attending regularly? Was she confirming her attendance at least 4 hours before the visits? One of the concerns was she was not bringing either any snacks for an extended period of time, in terms of the visit was an extended period of time, or the snacks that were being brought were not nutritious or to the liking of the children. So was she bringing healthy snacks? And the society then provided her with a list of the children's likes and the appropriate snacks that could be brought by the mom. Was the mom appropriately addressing the children's emotional dysregulation during visits? Was she appropriately addressing behavior? One of the things, for example, that she was doing repeatedly during visits is she would make comments to the children about when they return home. And we talked about in mediation the impact that those statements were having on the children. And her thought was, well, if I tell the children, I'm giving them hope and I'm reinforcing my love for them. The reverse, though, was ending up happening is that the children, at least the two eldest one, were feeling pressured by those comments. And their way of dealing with that pressure was not to attend the visits. And so mom was able to develop an understanding of those comments not being helpful. And so part of the checklist was also to talk about appropriate dialogue during visits between her and the children. And it was an actual checklist that the society worker then took after the mediation session, that particular mediation session, created the checklist. We reviewed the checklist at our next mediation session. And the goal was also then for, at the end of each visit, the worker and the mother would review the checklist for immediate feedback following the visit, right? So, to review that 2 months later is not going to have the impact, but providing immediate feedback and then also giving the mother a copy of that checklist, just because, people are not sometimes able to retain information when they're at a heightened state of emotion and feeling that they're being assessed. And so those checklists then would be provided on a continuous basis so that mom would have a visual in terms of where things are at and where there is room for movement and room for additional work. And then we set a date for a return to mediation so that we could all have an open dialogue about, the checklist. There would have been a couple visits then in between where we could have tweaked the checklist if need be, but it was clear, it was concise, it was measurable, And everyone knew, not just the mother in terms of her expectations, but what the expectations that the society would also then have to meet, so that the mom was clear on that as well. So I talked about a review process, and certainly having a review in mediation is quite instrumental in incremental trust building. And we build it in. We actually complete an intermediation report so that people aren't trying to remember what was discussed during mediation or what was agreed upon. There's an interim report that people can reflect on. And then they have a date that they can put in their books, and they know, okay, this is the date that we're coming back to review how things have been going. And at that point, so at our follow-up meeting, then we were able to discuss the long-term planning that needed to happen with the children. And because there had been an opportunity for clarity, and maybe, you know, it could be argued that that opportunity was always there, but certainly the mother felt that she was clear in terms of what those expectations were. She did consent to extended society care with an access plan for the longer term planning of the children, with the potential for the access to be increased in the future if it was deemed to be in the best interest of the children. Okay, so now we're going to do another case study, but this time it's more formalized here. Okay. So this case scenario, and I'm sure others have had similar scenarios, so it's not based on a particular situation. I've had many parents in similar circumstances. So we have a father who is 33, John, and Kiana, the mother, is 32. And they have two children, Nevaeh, who's 8, and Santina, who's 5. And the Children's Aid Society became involved when there was a domestic in the home. The police attended the home as neighbors had called due to concerns regarding yelling, screaming, and profanities. When the police attended, it was clear that both parents had been drinking. Neither parent was charged. However, John left the home for the night and is now back in the home. The CAS has continued to be involved with the family due to their concerns about emotional harm to the children as a result of exposure to parental conflict. John was involved in an extramarital affair with Kiana's best friend. The couple want to separate. However, they continue to live in the home as neither parent wants to leave the home in fear of the impact this may have regarding the parenting plan. And they've actually been directed. They both have secured lawyers, and their lawyers have directed neither one of them to leave the home until the parenting plan has been established. Parental communication is strained, particularly given the circumstances that resulted in the parental separation. The parents have consented to participate in child protection mediation to address the parenting plan and the parental conflict. Oh my goodness, are we out? Are we done? Are we at 12:15? Where did the time go? Okay. Well, Michael, how should we handle this?
Well, I think we can just move on to the next slide because that's what we were, but people can just think about how they would go through those steps. I think they can reflect on that.
I certainly have already given an example of this, however, yeah.
That's right. And
Yeah.
so I think we can start wrapping up now. I think, I think we've given a good foundation of the incremental trust process. And it's still in development, and we need to think about how we're going to expand this model. But I just really encourage folks to think about the cases that you're working on, how to put trust into the relationship, and think about a process. It doesn't have to be this one. It could be any one. But how are you going to put trust into the relationship to start building that trust? Because those trust violations oftentimes are what are causing havoc in these relationships. And so if we can get our heads around how to think about these differently, I think we're going to have more meaningful relationship with our clients. And for that, I think we're going to end it there.
Thanks, Michael. And yeah, I do certainly, if there are any further questions, feel free to reach out to either Michael or I. We'd be happy to address them. And I think, if maybe we could just go to this take-home message slide, Michael. Do you want me to? Patience is a virtue in trust building. Child-centered approaches foster trust and consideration of emotional well-being. All right, so thank you to everyone for your participation today. And I guess the next steps are, well, you're having lunch, so make